guys, welcome to our panel on the cutting edge of student loans. Thank you for coming this morning and talking to us about the fun subject of student loan debt at 10:30 on, I guess, day 2 of FinCon. Impressed you guys are here. I appreciate it. Let's get started. My name is Robert Farrington. I am the founder of the College Investor. Talk a lot about student loan debt, but I am not as smart as these guys next to me here. When it comes to loans, these guys are probably the smartest guys in the country when it comes to student loan debt. So I am not going to try to butcher their intro, so I'll let them go one at a time here if you want to start with Travis. But do you guys want to tell us a little about yourself and maybe share a fun fact about the highest amount of student loan debt you have helped a customer client with?
Oh, I'm going first because I'm gonna win.
Yeah.
So I'm Travis Hornsby, founder of StudentLoanPlanner.com. We are a flat fee student loan consulting service. We help make plans for people who have the biggest student loan debts in the country. We've helped 1,300 borrowers figure out $350 million of student loan debt so far. So, you know, monopoly money. And yeah, so we're just really excited to be here. Our typical person is in the 280K debt range, but it ranges from like 20K to the highest debt, 1.1 million.
Hi, I'm Joshua Cohen, and I don't have anyone with the debt that high. I'm the student loan lawyer. I've been doing this for 10 years now. I think I'm kind of the pioneer doing it as far as the law side goes. I eventually started a workshop teaching other lawyers and financial planners how to do this stuff as well. As a lawyer, I handle the whole gambit of it, so the stickier it is, the more I love it, because I'm going to sue somebody. And I also help discharge them in bankruptcy. We'll be talking about that a little bit. The highest I've seen, I actually have a couple that together owe just over $1 million in feds.
Wow. Hi, I'm Jay Fleischman. I'm also a lawyer. You get 3 lawyers today. How about that? I've been a lawyer for 23 years. I do everything from bankruptcy to debt collection abuse to credit reporting errors, and focusing almost entirely at this point on the needs of student loan borrowers and their families. My highest is only $820,000, so I'm kind of on the short end of things, but I'm thinking it's going to get higher, so just come back to me in a year. That's me.
Hi everyone, my name is Adam Minsky. I am also a lawyer. I focus on student loan stuff as well. I'm based in Boston. I practice in Mass and New York. I mostly help people in kind of 3 broad categories. I help folks who just have a lot of student loan debt and need some counseling and assistance navigating the system, especially for programs like public service loan forgiveness. I help folks who have a dispute of some kind with their lenders and servicers, and I defend people as well from the government and from big banks. My largest student debt, though, that I've seen is probably closer to $500,000 or $600,000. But just a few months ago, I got a lawsuit dismissed for a client for about $400,000 in private student loan debt. So that was big.
Nice. Thanks, guys. So we're going to ask some questions. We're going to talk about some of these important topics, and at the end, we are going to take some questions. So if you guys have any thoughts, save them for the end, and these guys will be happy to answer them for you. But let's kick it off. So we talked about the highest amount of student loan debt, but Travis, what do you kind of see is the average? Like, if I'm just a regular college grad today, like, what can I expect for student loan debt?
Yeah, I mean, like the average kind of debt is maybe about $36,000 or something like that. I have to review the latest numbers, but it's manageable for most people. I mean, you do have the situations where you've got the $10,000 debt borrower that went to a for-profit institution and is defaulting. You know, that's the most common default story. But the problem with student loan debt is it's not a one-size-fits-all description, right? There are people that have that $30,000 of debt as an undergrad that they can handle if they get the right counseling in their life and, you know, figure out a budget, pay it off aggressively. But there's also people that have 6 figures of student loan debt, which is what I typically focus on. There's about 6% of the borrowers have more than $100,000 of student loan debt. So I call that the mortgage club, right? And so those kind of borrowers went to graduate school or they happen to be parents that have Parent Plus loans for their kids. So that is the segment of the population that is exploding. That we can talk about more if people want to hear it, but that portion right now is the folks that could really break the system.
Yeah, so how much is it growing? I mean, I remember when I started this about 9 years ago, the average was only in like the 20s. Now we're up to 36, and you see this growing trend of the 100K plus, and we always think doctors, but it's clearly not all doctors that are achieving that. So how fast is it growing?
So the really interesting thing in the statistics right now is what you're noticing is a good economy. Right? So the people that have less than $60,000 of student loan debt are actually paying it off and getting rid of it in a lot of cases. And so that's why you saw student loan growth. It was about in the mid-teens back in like the early 2000s and mid-2000 teens, right? And then now you're at a point where the student loan debt growth is maybe around like 4 or 5%, so it's slowed down a ton. But the growth, I'll just give you one stat, the growth in the segment of borrowers that owes more than $200,000 of student loan debt, the annualized growth rate is 17% in those borrowers in that segment. So in other words, the number of borrowers that owe more than 200 grand is going to double in about 4.5 years.
That's crazy. That is a lot of debt. And I think the other big concern that a lot of people have is, without getting into politics, there are just so many proposals to change things, right? And that makes things very complicated for borrowers. So one of the biggest is there are so many people concerned about public service loan forgiveness. It's been talked about by multiple administrations, multiple changes. It sounds like a phenomenal program, but could it go away? So Adam, like kind of what's going on with public service loan forgiveness?
Sure, yeah. So for those who don't know, so public service loan forgiveness is a program that allows borrowers to get their loans forgiven after a certain number of years of what we call qualifying payments. Now that's where it gets complicated. What is a qualifying payment? The best way to think about it, because it's not enough to just be working in a public service field. You have to be doing literally everything right. So you have to have the right type of loan, which is a federal direct loan. Not all federal loans are direct, so it has to be a direct federal loan. You have to be in repayment on a particular type of repayment plan, which in most cases is going to be an income-driven repayment plan, where you have a payment tied to your income. So that means even if you're on a plan where you pay more than you would be paying under an income-driven plan, that probably doesn't count. So you have to be in a particular type of plan. And then number 3, you have to be working full-time in a public service field, which is generally a government entity at any level, or a 501c3 nonprofit organization. And full-time is at least 30 hours per week. If you meet all those criteria in 1 month, that month's payment counts if it's on time. You do that 120 times, that adds up to 10 years if the payments are made consecutively, but they don't necessarily have to be made one after another, which means it would just take longer than 10 years. If you fulfill those requirements, any remaining balance gets forgiven tax-free after 120 qualifying payments. So it's a great program. It was enacted in October of 2007. It's not retroactive to before that date. So that means the soonest anyone could qualify was just about a year ago in October of 2017. Now, there have been proposals to eliminate the program or repeal it or defund it entirely. So far, those proposals, number 1, would have grandfathered in current borrowers who are on track for the program. And number 2, all the proposals so far have not passed. One came from the executive branch, one came from Congress, neither went anywhere. Even the most extreme proposals would grandfather people in. So I'm hopeful that if they did make any changes, current borrowers would be okay, but Congress could do anything, they could repeal it. One major change we've seen is that Congress passed a law just a few months ago called Temporary Expanded Public Service Loan Forgiveness, which creates a fund that will allow borrowers on a case-by-case basis to petition the Department of Education to count non-qualifying payments that were made under the wrong repayment plan. Meaning if you were on an extended or graduated plan, you can potentially have those payments count subject to funding, but they haven't created a fix yet for making payments on the wrong type of loan. We're hoping we'll get a fix for that, but we'll see.
Just real quick.
Yeah, go ahead.
The reason I feel like public service loan forgiveness is not going away right now is all of the congressional staffers qualify for it. Which means the congressmen are not going to get rid of it if they realize they're screwing their own staff, and that's a figurative.
Well, also the largest and most powerful union in the country is UFT. It's the teachers union. Every teacher is going to qualify for public service loan forgiveness. Can you imagine any person, any member of Congress, voting to get rid of PSLF and having even a remote chance of being reelected?
Well, just
No.
think about it. It's teachers, nurses, it's the military, it's police officers, it's
military.
firefighters. So it's all these constituents that you don't want to make them mad, right? So
And these guys would
They
sue
won't put the fire out when
Right.
your house is on fire.
right, exactly.
So I mean, you guys are saying that it won't go away, but then you see these headlines that come out, right? So Jay, maybe you want to take this. Like, why am I seeing a headline that comes out that 99% of borrowers who have applied for PSLF are not getting it?
Well, you've got to realize that when PSLF came out in October of '07, first of all, the only income-driven repayment plan that was available was called ICR, which for most people is just a terrible idea. And in fact, for most people who look at ICR, they'll find that their payments are lower under an extended graduated repayment plan where the payments start low for 2 years and then they go up every 2 years. So most people, if they were in a financially difficult position, were opting towards one of the extended graduated repayment options. Second of all, up until June 30th, 2010, there was a non-direct loan program called the FIEL program, whereby private lenders were empowered to lend federally guaranteed student loan money. And so a lot of borrowers had FIEL loans. So you had unqualified loans, you had people who were in non-qualified repayment options, and even for those people who had direct loans, nobody really publicized public service loan forgiveness when it came out. Servicers still don't give very great information, but they didn't give any information out. So a lot of borrowers just didn't know about it. Now, 10 years later, they make an application and they get denied, but this is why they get denied, because there was a lack of education in the marketplace.
Interesting. Okay, well, I think along with that lack of education, we hear a lot that student loans can never, ever be discharged in bankruptcy. And I feel that the fact that there's 3 lawyers here, lawyers here. Lawyers here?
Wow, if that was
Hey, that's a Freudian slip right there.
Dr. Freud, I presume.
I don't know. But yeah, so can student loans be discharged in bankruptcy? Jay, Josh, you guys have an opinion
So
or
Jay,
proof?
can they be discharged in bankruptcy?
Absolutely,
So why doesn't everyone file a bankruptcy and get rid of them?
because everybody says that they can't be discharged in bankruptcy. Thank you. You've been a great audience. Tip your servers. We're here all week. No, but seriously, the student loans are not automatically going to be wiped out in bankruptcy. However, first of all, not every student loan is a student loan for the purposes of bankruptcy law. It's a whole nother 5-hour session that I'm not going to bore you with. Second of all, most people look at the discharge of student loans in bankruptcy as being such a steep hill to climb that they're not willing to even try. They've been conditioned to believe that there is no way that it's ever going to happen. It's expensive. Most lawyers who handle bankruptcy cases are not in a position to handle the cases because they just don't understand. And so most people who have a student loan issue don't even walk through the bankruptcy door. What's interesting is that the vast majority of student loan discharges in bankruptcy are being brought by individual borrowers who don't even have a lawyer. And they're bumbling their way through the court system. Some of them have been successful. Many of them are not successful, but not because they have a bad set of facts, but because they just don't understand how the system operates, so they bounce around like pinballs. So many more people, if they understood what the guidelines were and they had either competent representation or they took enough time to understand the guidelines on their own, there would be a lot greater success of that.
I'm going to add to it. There are quite a few bankruptcy judges out there that have sat on panels like this that ask us attorneys to please bring us cases. We want these cases. We want to start discharging. We want to take the law and change it. They can't change what's out there without the cases in front of them. Bankruptcy attorneys are still afraid because if they screw up, they get sued or something. And it's expensive. That's the other catch-22. You need money to get rid of your debt. And makes sense, except the people that most qualify don't have the money for the attorney, they can't do the bankruptcy. And of course, you have to file a bankruptcy, which that scares a lot of people as well. I can tell you, it does happen though. I've done it. Jay, have you discharged?
Yeah.
Okay, so we have done this. It is possible.
That's great to hear.
Well, and if I can just add one other thing. People who file for bankruptcy primarily because of a student loan debt, you need to understand that that's a litigation posture. You've got one party pitted against another in a court of law with an actual judge who wears the robe, and no powdered wigs here, but does wear a robe. And as much as the borrower has at stake financially, the lending institution or the government standing on the other side of the room, literally and figuratively, has even more to lose because they don't want to be the one that killed the goose that lays the golden egg. And so what I found, I know that you found as well, is that if you've got somebody who's looking for a little bit of leverage to get a better deal than they would otherwise be getting, that's a great way to do it. You bring everybody to the table, and you're bringing decision makers to the table, and you're getting a lot better of a result than you can ever imagine in many cases. So.
Just one more quick point about bankruptcy as well, and I agree with everything that's been said. Bankruptcy can also be a useful tool regardless of whether or not you get a discharge, because number one, you can more easily discharge other debts that might be weighing the consumer down. And number two, especially for co-signing situations, there's something called a co-debtor stay, where if one party files for bankruptcy, all collections must stop against the co-debtor on that account. And a bankruptcy can last for up to 5 years if you do a Chapter 13, and that can give both parties enough time to freeze collections. And of course, a discharge would be great. If that can't happen on the other side of bankruptcy, if the student loan is still there, you might have more options there for you to deal with it at that point.
Awesome. I think one of the most common questions I get on my site is because these individuals, these consumers, read these headlines. And so, Josh, you love to sue people, you told us. I like that. But they see that like Navient is being sued or FedLoan is being sued. And the borrowers will reach out to me and they'll be like, they're being sued. I don't have to pay my loans anymore. Isn't that great? And that's clearly not true. But what do all these lawsuits mean?
They mean somebody screwed up. The thing is, we already knew that. Okay, think about it. You've got 3 lawyers up here that do nothing but student loan stuff. Travis, you do all student loan stuff. We shouldn't be here. If the industry did what it was supposed to do, we wouldn't be here. We'd be doing something else, which is fine. When you take a look at those lawsuits, first of all, almost all of them, the big ones, are done by government agencies. The Consumer Financial Protection Bureau or state attorney generals, they've got the power to do this stuff. What they're looking at is the Higher Education Act that controls the federal loan system, and they're saying, and they're starting to nitpick, and they're going, oh, well, Company A, you haven't done exactly what you're supposed to do under the law. You're not offering all of these plans, or you're advancing payments when you're not supposed to, things of that sort. Or you're delaying people. Now, look, the servicer's job is to make sure people don't default. If you're smart about money, that would mean, okay, keep them in a payment plan so that they're still paying and they don't default. Instead, what the industry says is, I'm going to give them a forbearance because you got a forbearance over the phone. There's nothing else to do. You're done. If you put them on a payment plan, you got to process the paperwork and blah, 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 blah. So they take the easy way out. So part of this has been about forcing people into forbearance instead of on a payment plan, which delays forgiveness or public service loan forgiveness. Interest continues and the interest capitalizes, it's interest on interest. They're ballooning the market. And that's what a lot of these lawsuits are about. Does that mean that we don't have to pay? Absolutely not. And in fact, some of the claims that they're bringing are claims that we as individuals aren't allowed to bring. Accounting is specifically spelled out in the Higher Education Act. So if we think there's a false accounting claim or something went wrong, we don't actually have the legal right to sue them for it. Attorney generals do. Consumer Financial Protection Bureau does. And that's what they're about.
I just want to say that real quick, I blame the universities more than the borrower, or more than the servicers. So the reason for this is because, yes, when Fed loan or non-lender somebody screws up and compounds the debt, like that is hurting people, that is compounding the problem. But with the Grad Plus loan system, you can borrow an unlimited amount of money. How much is the cost of attendance? Whatever you want it to be, right? And so I've actually had kind of discussions with deans who shall not be named because they wanted it to be off the record, but in general, I can say that the universities are sitting there and saying, what do we want to do? We want to make money, right? And so you've got all of these graduate programs that are targeting people, giving people false hope, false dreams, saying, hey, you can get doctor after your name, right? You can get, your doctorate of whatever. And so you see this explosion of credentials and over-credentializing professions so that the universities can go from master's degrees to doctorate degrees and put more money in the pockets. And the deans off the record will say, this is because what I get paid on is how big is my college, how prestigious is my college, and where does my college fall in the ranking of the U.S. News and World Report rankings. That's what they care about. And if they raise the tuition, they're going to get some angry letters from some students, but that's all they have to deal with, right? And as long as people continue to go to these programs and they continue to fill the seats, that's all they have to care about. So if you look at profession after profession, from veterinarians to physical therapists to pharmacists, there are giant crises happening in these professions where the applicants per seat is declining. So we're going to get into a situation here, I think, where the emperor is going to be revealed that has no clothes. And so I just kind of wanted to say, yes, the servicers suck. They are awful. They should be fired. We should get new servicers. You know what? Let's the five of us just come up with one. I bet we could probably do a better job, right? I mean, it's ridiculous. Probably my I don't know, my grandmother could do a better job, frankly. But the universities deserve a lot of blame, and nobody is calling them out on it, and they are making Wall Street bankers look non-profitable.
Yeah, I think that ROI is extremely important for the individuals to consider. But Adam, you were sharing a little bit, you're helping parents with large amounts of debt. So these are people that are older that we don't think about necessarily as these recent college grads or graduate students that went to college and took big loans. But how are we seeing this people that are nearing retirement, this group of people that have huge student loan debts when they should be looking at having huge 401k balances?
Yeah, it's a big problem. When I tell people that I work with student loan borrowers and their families, and this is the focus of my entire practice, I think people assume that my clients are a bunch of 22 and 23-year-olds, and the reality is that I have a lot of older borrowers. I have a lot of parents. I have grandparents who are clients. I'm working with a 75-year-old right now. The average age of my client is probably in their 40s. You're on 20, 30-year payment terms for your own student loans, and you take out loans for your kids, it just compounds the problem. There's two ways primarily that parents take on some form of student debt. One is in the form of a particular type of federal loan called a Federal Parent Plus loan, which is a loan specifically for the parent. The parent is the borrower. The student has no responsibility for that loan at all. It's not a co-signed situation, it's just the parent. And if the student can't pay, it doesn't matter because the parent is the one on the hook. And compared to other types of federal student loans, parent loans generally have higher interest rates and fewer repayment options. There's a menu of income-driven plans available for student borrowers that some of you may have heard of, income-based repayment, pay-as-you-earn. Those are not available for Parent Plus borrowers. There is another type of income-driven plan called ICR, which Jay mentioned earlier, which is okay, but not a cheap plan, and a lot of people still can't afford those payments. The other scenario are private student loans where the parent is a co-signer or guarantor on that loan, maybe to get a lower rate, or the student can't get it because they have no credit unless they have a co-signer. And that becomes a problem if the student can't pay and the parent can't pay, and now you have two people on the hook, and it gets really bad. For federal loans, when they go into default, the consequences can be really serious. The government, without a court order, without needing to go through the court system, can garnish people's wages, and more importantly, for older borrowers, they can garnish Social Security. without a court order. Private lenders have to go through the court system. They have to sue you, but once they get that state court judgment, depending on what state you're in, they can put a lien on your house, they could go after wages and assets and all of that. So it's a real serious problem, and I think a lot of parents are struggling. Usually in these types of scenarios, obviously depends on the specifics, but for Parent Plus borrowers, we explore options like direct loan consolidation to stretch out the term, see if we can get them eligible for ICR. Sometimes for married borrowers, filing taxes separately and doing ICR can provide some relief. There sometimes are tax consequences to doing that, but by excluding the spouse's income, you might in some cases be able to lower that payment to make it be more affordable. Sometimes it's about bridging the gap between now and retirement. If we can kind of put things in a holding pattern and then you're expecting to be on a lower fixed income in retirement, ICR can really come in handy. For private loans, it's tougher because there is no income-driven repayment, there is no loan forgiveness, and so for those types of situations, if the borrower and the co-borrower cannot afford payments, then default is inevitable. There might be more flexibility to work out a settlement or something like that to kind of get rid of the debt for less. But it's not a pretty situation for parents at all, and a lot of families are struggling.
Yeah, so I want people to die with the debt in this situation. Yeah. So the reason is this. So actually, if you're a 60-year-old, the best thing that you can do is borrow as much money as, if you're on a modest income, let me say, a very modest income, like $50K in retirement kind of income. The best thing you can do under the federal loan rules is borrow as much as possible, consolidate it to put it into a Parent Plus, like direct consolidation loan, and get onto ICR. Now, if you're the typical American living on Social Security, maybe $30,000, $40,000, you can pay, you can exclude some of the Social Security from taxable income, right? So it's based on your taxable income. So what you do is you can either forbear it or get them to put a lot of money into the retirement accounts to keep that AGI low until they retire. And then when they retire, you can get somebody paying maybe $100 to $200 a month for the rest of their lives. And guess what? There is a tax bomb at the end of it. In 25 years, you have to pay taxes on the forgiven balance. But if you die, you don't have to worry about that. And another thing is, if you're in a nursing home, Medicaid covers, like 2/3 of the Medicaid money goes to paying for middle-class people's nursing home bills. So if you're in the nursing home, I guess you're just going to have to pretend that you have dementia and you can't remember that you took out the student loan, and then they're not going to be able to get it.
Well, so I've counseled borrowers in this type of situation, and they don't even need to wait until they die, because if you're not able to work anymore because of a physical or psychological condition, you actually are entitled to a disability discharge of your federal student loans. That's also a tax-free type of discharge, and you don't need to wait till you die. So everyone wins.
So basically, if you have some parents, get them to take out some Parent Plus loans to send you to a new bachelor's program. I'm not an attorney. Consult with one of these guys. No liability here, folks. But that's the problem with the system. When you pay based on your income, nobody cares how much you borrow, right? It doesn't matter. You could have $500,000 of loans and make $30,000 a year, which is actually a common scenario that I see, and actually be okay because you're paying 10% of your discretionary income. Discretionary income gives you a big deduction, right? So you could pay $50 a month on $500,000 of loans. And so the actual pricing mechanism for higher education is totally broken.
Okay, and the other part that he missed here is the federal loan dies with them. It doesn't affect the estate.
Yeah.
Private loan does.
Right. That's an important distinction between federal and private loans. Federal loans are discharged upon the death of the borrower, no matter what, and that's a tax-free type of discharge. Private student loans, that's not necessarily true. The cosigner is still on the hook if the borrower dies, and vice versa. They can pursue the other person, and even if it gets discharged or canceled, that likely would be a taxable event to the estate, and that could haunt the family if they're going to get some sort of inheritance or something. So that's a big difference.
So let's talk a little about private. Go ahead.
One just other thing. With respect to federal Parent Plus loans, the death discharge is discharge on the death of the parent borrower, or, and I hate to be morbid about this, or the child student. So
who benefited from the loan. Yeah.
Right.
Yeah.
So in the unfortunate event that you've got somebody who's a Parent Plus borrower and their child passes away, that Parent Plus loan is also going to be subject to a death discharge.
So we kind of talked a little about the differences there about federal and private. So one of the things that's been in the news a lot is people getting their private loans forgiven because of servicers screwing things up. So they lost paperwork or things like that. Like, Jay, is this a thing or is this fake news?
It's a thing. It's a real thing. It's a big thing. There primarily been two entities that have dealt in private student lending just historically. One is Sallie Mae, now Navient, and the other was an entity that was called National Collegiate Student Loan Trust, and it was a collection of financial vehicles that were all rolled into the same thing. And any of you who followed any of the securitization issues of mortgages leading up to Lehman and the whole crash, it's the exact same thing all over again. Because there has been so much money in the market, and because there has been so much demand, we see a lot of the same sloppy paperwork in the private student loan arena that we saw in the mortgage arena. And bear in mind, this is not an issue of, I want to get a free education. This isn't, I want to get out of my student loans because, well, the hell with them because they lost some paperwork. This is a way of leveling the playing field between the borrower, who has been subjected often to variable interest rates with no cap on them, an inability to gain forbearances or deferments, lenders and servicers that refuse to allow their guarantors to be released, even when by all rights they should be able to have that done. So this is a way of leveling the playing field. All of that having been said, and I have had borrowers with $250,000 worth of private student loans get sued and get the loans wiped out because the lender and servicer are unable to produce chain of title, to produce accurate accounting records. You would think that accounting would be kind of an easy thing to do. But accounting records are abysmal and most of the time not even kept. All of that having been said, a lot of it depends upon your individual location, because the law is the law, but the person who decides what law is going to be utilized is the judge, who sits up on their lectern with their black robe. And I'll tell you a quick story. I had two sets of borrowers. One was a mother and daughter, and the other one was a husband and wife. They were both sued in California State Court in LA County in two separate courthouses, because LA is kind of a big place, so there are multiple courthouses. And they're both sued by the same entity, same National Collegiate Student Loan Trust entity, for about the same amount of money for the same schools in the same period of time. So everything was remarkably the same. They both get sued. I defend both of the cases. One case, the judge who was hearing the case was the former president of the Malibu Yacht Club. In the other case, the judge presiding over the case was a former legal aid attorney. One case I lost, one case I won. Anybody want to guess which one I won and which one I lost? The president of the Malibu Yacht Club looked down and effectively said, well, I paid mine, I'm paying my kids, so you're going to pay yours, and it doesn't matter how badly they screwed up. The other judge, who was the former legal aid attorney, actually looked at the paperwork and said, well, we can't match up any of their numbers, any of their claims, any of their dates of payment. Nothing that they've got is substantiated, and so we're not going to allow them to collect the money. I use this as an illustration for all of my clients. A lot of times, well, in every case, it doesn't matter who's right or wrong. It never matters. And as Robert and I discussed last night, it's all a business decision. It doesn't matter who's right or who's wrong, because whoever wins or loses, there's one person Well, there are 3 people in front of you today who are going to be very happy because we're going to get paid. The 3 lawyers are always going to get paid. My wife loves it when I make money. My kid loves it when I make money. It's a nice thing. My client doesn't get a refund or a rebate just because they won or lost a lawsuit. And so it's a business decision. How much money are you willing to put into this versus what kind of a deal can you get from the other party and using litigation as leverage? And I think all 3 of us are pretty happy with some of the leverage that we've gotten.
I think that's a scary thing. And so I think for borrowers that being sued is probably the most scary thing they've encountered in their dealings with personal finance. And that's a tough event, but it's also a pay-to-play system, which I think is very hard for people to understand that the law is the law, but it's still pay-to-play. And it doesn't matter. So I guess this is for everybody. Federal loans, private loans, these are all large companies. You interact with a call center. There's a lot of different companies around the space that might provide help, might not provide help. Like, how can a borrower, like, really just protect themselves? Like, what advice do you have to, you know, really just ensure that they are doing everything they can to not fall into the situation and protect themselves?
So if they're not up here, it's a scam. Sorry.
No. So, I mean, there's a debate among us and other professionals about whether or not a licensed professional needs to be the person providing assistance to student loan borrowers. And I don't think you need to be a licensed professional. You know, I think that there are some benefits to having an oversight body of some kind. You know, lawyers get a bad rap, but at the end of the day, you know, we can be disbarred if we do something very bad. CFPs also have a regulatory body. CPAs have a regulatory body. But this all isn't necessarily rocket science, and I don't think that you need to have a professional designation to be able to do this work. There are some things that I think are generally red flags for people who are seeking advice from some sort of organization or company. Number one, not having any actual person affiliated with it. If you can't see who is behind this company, if it's just a wonderful sounding name, Debt Relief USA, .USA or something, like that smells a little fishy.
Obama student loan forgiveness.
So if it has the word, president's name, loan forgiveness after it, because when the administration changed, they just went from Obama loan forgiveness to Trump loan forgiveness. That's probably a scam as well. Anything that says you got to apply today, it's a limited time type of thing, that's a problem.
Get it now.
In general, now this isn't. This is more complicated, but the FCC and the state, the equivalent state bodies, have been going after companies that either take an upfront fee or require some sort of what they call like a monthly maintenance fee to basically fill out paperwork that the borrower can complete automatically. Now, we all help people with forms and applications, and we can provide services on an ongoing basis, so it gets a little complicated. But, I've had clients who, it's the income-driven repayment application, for instance, it's way messier than it should be. It's like a 30-question choose-your-own-adventure novel when basically all they need is your name, your income, and your loan, info, and it shouldn't be that hard, but, you got to go through this complicated form. But the point is, it's just a form, you submit it, and then you're done until it's time to recertify in 12 months. There's no reason that, I've had clients come to me and say, well, I've been paying this company $250 a month to do my income-driven, payment application. No, that doesn't sound right.
Yeah.
That's not what you should be doing.
I was just going to say that, my goal is to get them a plan, and then the ones who are really screwed over, I send to these guys. Oops. So the thing is you have to figure out, do you pay this off and get super aggressive, or do you go for forgiveness? That is ultimately the question that you're trying to do. And if you are in such a bad situation where discharge is an option, you can talk about that. But before you get there, before you destroy your credit, before you wreck everything, you want to figure out refinancing or forgiveness, or payoff or forgiveness. Yeah. And so it's a strategy that people need. So that's why, like, Student Loan Planner, we don't do document preparation. We don't help people with forms. Like, we'll answer questions about them, but that's really bad in my experience, to let people check out of the process and not be owners of their own situation. What the confusion is having a plan, having a strategy in place and how you get out of this. And so if you have, 3 times your income in debt. I've seen people pay, on $200,000 of loans, they'll pay like $1,200 a month. Well, guess what? If you do that, you're going to keep that loan around for 20 years. Oh, guess what? You can get on pay-as-you-earn and pay $400 a month, have a tax bomb at the end of it, which may or may not happen. It does happen.
Which you can prepare for.
Which you
and
can
plan
prepare for, right? But if you're paying $1,200 a month, you're going to take 20 to 25 years to pay it off anyway.
Right.
So what the heck are you doing? You're flushing money down the toilet. I've had this argument with people that don't understand that still think that the only thing you can do with student loan debt is to pay it off, right? It's a credit card. It's Dave Ramsey. Get rid of it, right? And then they do that for a year, these chiropractors or veterinarians or somebody like that, and they'll pay 50% of their income on their debt, and they'll say, holy cow, I have nothing in my retirement savings. That was such a freaking mistake. What am I doing now? So I would just say that the situation is people need to have a plan. They need to know what they're doing. They need to understand how to get out of the debt in the first place so they don't have to go talk to these guys. No offense.
No, the bottom line is, who is in control of the decision making? When anyone comes to us, at the end of the day, the client should understand enough that they can go, oh, I want this and I want this. Whether they understand the full plan, that's maybe more education, but they understand what IDR, IBR, all of that is. They understand why they're consolidating or doing this. They understand it. They're the decision maker. A scam company never allows that. They say, you're doing this, you're doing this. Oh, okay.
$1,000.
Yeah.
That right there is it. Who has control at the end of the day?
My markers are as follows. Anybody who uses the word guaranteed, we guarantee you that we're going to fill in the blank. Guarantee is completely off the table. And the other thing, the other way to determine that you're dealing with a scam is anybody who says to the borrower, don't worry, we'll take care of everything. Don't worry, again, goes back to education and who's in the driver's seat and what do they know and understand. This is a matter of education. That's all it is. And yeah, it's like swimming through peanut butter sometimes, but if you understand what your situation is and you can match that up to the solution and you know why you're doing what you're doing. It's like talking to my 11-and-a-half-year-old. Hey, why did you do this stupid thing? I don't know. That's not an answer, is it? Well, it is to him, but it's not an answer. And when you've got a borrower who's doing something that they don't understand why they're doing it, they're paying somebody for something and they're doing something for them, but they're not really clear what it is, but they made promises and guarantees, that's the scam.
Awesome, guys. Well, I know we have some awesome things we want to cover, but I do want to leave some time for questions here before this is up. So does anybody out there have any student loan questions? Ooh, good. Here, I'm going to hop down here and I'm bringing the mic.
Hi, everyone. Thank you so much for hosting this panel. Myself and my co-chair, Sheena, we're representing a brand called the Student Loan Doctor, so much similar work to the Student Loan Planner. So thank you for this topic. My question, I wanted to get back to, Adam, I think you were leading the discussion. What advice would you give for private student loan borrowers, parents, the borrower themselves, on how to protect their assets? Let's say they don't want to go the bankruptcy route, but let's say they do pass away. I had it happen to a friend suddenly at age 28, owned a home. What would you give as a prescription, if you will, to really protect their assets prior to if death could happen at any time?
Sure, yeah, so that's a good question. So in part, it does depend on state law. One of the things that I always advise clients who are struggling to do is look at the laws in your state regarding homestead protection. So in Massachusetts, where I'm based, you can if your primary asset is your home and that's where you live and you've got less than $500,000 in equity in it, that is protected. Now they can put a lien on the home, but they can't take your home. And so they're not going to be able to kick you out of your house. Other states don't have as generous of a protection as that, but that's something where it might be worth it to look into that. Also, in terms of bank accounts and things like that, if you don't, there are You don't want to transfer assets to someone else fraudulently, because that could be a crime. But you also want to minimize, what you've got in a bank account in your name as well. So, if you're married or you've got kids, it might make sense to put future income disbursements into some other accounts. Really, what I often recommend to people, especially for private loans, is that if this is defaulting or it's already defaulted, what we want to do is start putting aside money for a settlement now, because they may not sue you for a year, 2 years, 5 years, ever. But if you're starting to put away just a little bit per month now, if they take a little while to sue you, you'll have something to work with and you can negotiate. And for private loans in particular, it often is possible to get a decent settlement. And so that's a way to prepare.
Hi, I'm Michael Lux from the Student Loan Sherpa. You guys have a room full of bloggers here, and I know personally I get contacted all the time by companies that I would consider wolves in sheep's clothing. These guys, put on a nice picture for, the affiliate agreement they want to do, but they're scams. How would you advise bloggers on making sure they don't get into bed with the wrong companies?
I have an affiliate program. No, just kidding. So I think that the main thing is just what they talked about, basically. Do they have lots of reviews? Do they have a person attached? Are they willing to put their name and their face out there in public? And have they been around for more than a couple years? A lot of these places have shut down. But I think that in general, if you don't know, if you're not an expert in the space, just approach it with an abundance of caution.
And I'll just share personally, I think you have to really be aware of what they're doing. So a lot of the companies that reach out really do go the private loan route, and they want to settle those private loans, very similar to what these guys do, but they might have some guarantees or things that they really shouldn't be saying to those customers. You'll be very rare to find people that settle private or do anything with federal student loans other than potentially paperwork processing. But I think there's a fintech that's launching this week at the fintech competition that's in that space. And then these guys, like a financial planner, these type of experts, they can really help in that space as well. Cool.
Thank you, gentlemen, for sharing your expertise this morning. This has been really enlightening. I'm curious, with regards to Pslf risk, so you addressed, the reasons that is unlikely. I am a financial planner for anesthesiologists and physicians and other high earners. There's obviously a difference between a teacher getting 40K released in PSLF and a neurosurgeon who took out 500K in undergrad med school and then did 6 years worth of residency and then a couple more of fellowship, and then by the time they start making 800K a year, they're about to get forgiven. Mm-hmm. So I'm curious, with regards to PSLF and high earners and people who get close to maybe a 7-figure sum discharged, is there any cognizance with Congress or the executive branch of perhaps capping PSLF or doing something so they don't piss off all the teachers and firefighters, but maybe eliminate some of the right tail forgiveness? Or if not, what is the most likely way that PSLF might be modified in the coming years?
So there has been talk of a cap in the past. A cap has never been implemented, and there is no cap right now, and there's no imminent proposal that would impose a cap. Doctors and lawyers are the ones that are most often targeted rhetorically when they're attacking the program. And so I think that, the doctors that are, who have $400,000 or $500,000 in student loan debt and make about that much per year are easy targets to attack the entire program. I don't see them imposing a cap retroactively on borrowers who are currently on track. I mentioned before, all proposals so far that would have scaled back or repealed the program would have grandfathered in current borrowers. I don't see, they could do anything, I want to be clear, but I think that they would grandfather in current borrowers. With regard to doctors in this type of situation, I'll just say real quickly here that I deal with a lot of these types of clients, and the question is whether or not public service loan forgiveness is even worth it for those people. And it really comes down to doing the numbers. If you get into income-driven repayment in residency, you have 4 years already where you've paid very little and your balance probably hasn't moved. And then the question is, what are your payments going to be for the next 6 years? Do you save money or not? Most of the time, even with large incomes, they do save money if they're going to be working in the right field.
All right, guys, well, that is our time, and I just saw 4 more hands go up. But I'm sure these guys will be available right now and in the hallway after this. So thank you guys so much for attending this panel, and we'll be around if you have any questions.